And this meeting of the Complaint Review Committee, the Guardianship Certification Advisory Board, will begin. First up, we'll call the roll. I'm Jamie McLean. I'm here. Judge Burwell,
Here.
Mr. Armstrong.
Here.
Okay, the entire committee is present. We do have a quorum. Mr. Director, do you have any remarks for us?
No, I just want to say thank you for your service, and staff members present are myself, Melinda Saucedo, Bina Mohan, Amy Smith, Thais Holcomb, and Rachel Davis.
Okay, great. Thank you. Looks like we just primarily have one matter on the agenda today, and that is the reconsideration of the matter of Ginger Lot, cause number 0593, referred back to the committee from the commission at its last meeting. And we're ready to go. Staff, did y'all have an introduction or preface as to why we have this returned?
Yes, Mr. Chairman, committee members, this case is before you again because at the last commission meeting, the commission voted to reject the agreed order that contained the sanction that you all proposed, which was a 5-year probated suspension subject to certain reporting requirements and the assessment of a $5,000 penalty. At the commission meeting, staff argued two main points. The first one was that the sanction was inconsistent with a prior case that the commission decided. It was a Christian Clausen case. I don't know if you all remember that. In that case, Mr. Clausen voluntarily and permanently surrendered his certification and agreed to pay a $2,000 penalty for violations very similar to Ginger Lot's. And after the meeting, after you all convened to consider the Lot case, staff realized how difficult it would be to monitor Miss Lot over the period of her probated suspension. That was information that we didn't know at the time. And it was made clear when Miss Lot turned over some paperwork that was inaccurate. We realized that we had to audit her submissions every time during the period of probated suspension, and that would prove very burdensome to staff. At the commission meeting, concerns were also raised that Miss Lot was practicing law without a license because she was not being represented by an attorney. One member requested that staff file a complaint against her with the state bar. So the commission voted to reject the agreed order and remand the case to the committee for reconsideration. A couple of things have happened after the commission meeting. First, Miss Lot stated that she submitted a letter stating she would resign as guardian and would not renew her certification, and submitted a list of cases that she withdrew from. She also hired an attorney who submitted a letter that you all have before you. But what I want to emphasize is that there's nothing in the letter from the attorney that is new information for the committee, other than the fact that Ms. Lot resigned as guardian. The committee has already considered the points that the attorney raises, such as the practical challenges of counties like Harris, where guardians are in short supply and high demand. The committee likewise considered that no one in the court system has filed a complaint against Ms. Lot, and that none of her wards, to our knowledge, were abused or neglected. So none of this is new information. So the compliance staff is advocating that the laws of the commission governing the conduct of guardians are not aspirational. They are standards set by the commission that must be followed by all certified guardians. We believe that we have strong evidence to support the violations. Ultimately, we believe that it would undermine the authority of the commission to treat a case like Ms. Lot's lightly. We're a regulatory body. We're the standard bearers of the rules for guardians, and Ms. Lot represents a case where a guardian obviously violated the regulations governing guardianship cases. So we urge that the committee revoke Ms. Lott's certification, which does not expire until March 2025, or in the alternative, accept a permanent surrender of her guardianship certification. We also argue that the committee impose a $5,000 penalty, and that's half of what we originally recommended, and that the penalty be due within 3 years of the final order. And we also present for the committee's consideration what we should do with the allegation that she was practicing law without a license. Thank you.
I have a,
Okay.
I have a,
Sorry, Judge.
can we revoke her license prior to the time she has gotten out of all the cases? The courts have accepted her resignations.
I understand that creates a practical difficulty. I don't know how many cases of her she's actually resigned from. But I think we did that in Clausen, but staff may want to remind me if that was a case. That would provide an additional basis for her to withdraw if we were to revoke her certification.
That's what we did with Clausen. It was, we notified the court, and then Dallas County particularly began searching for guardians or if cases could be closed. But he still submitted letters of resignation and requesting if another guardian, a successor guardian, could be appointed.
And it is one thing to consider is that the commission meets in May, so she has time in the intervening months to file resignations for all of her cases. So the revocation would kick in after she's completed those filings.
On the materials that we received, on page 15 of your amended staff recommendation, it had a penalty of 10,000, but are you changing that to 5,000 now?
Yes, ma'am, we are. At the time, we thought this was a far more egregious case than Clausen. Given her background as a court coordinator in the probate system, she should have known what the regulations were, and she violated them nevertheless, and over a long period of time.
As I recall, at the commission meeting, one of the, I believe, one of the first reasons given for recommending that the commission not accept the agreed order that was proposed was that in January, the Guardian had filed an incomplete or inaccurate annual report of the Guardian.
Yes, we began to appreciate the difficulties of monitoring when we got that inaccurate information, and I know that Melinda can speak in greater detail about that.
Yes, I reviewed her the private professional annual report, and it wasn't accurate. There were some words that she hadn't included that we spoke about or that we knew about in her complaint case. So I had to send it back to her and say, you need to include everybody that you were pointed to in 2023. And so then she ended up sending us back another report.
Okay. And was the second report complete?
As far as I could tell, yes.
And when did the second report come in?
So give me a moment. It was January 22nd.
Okay. And when are the annual reports due to be filed every year?
By January 31st.
Okay. Okay. So in the end, she was timely.
Yes. I just kicked it back to her because it wasn't correct. She didn't list everybody.
By the way, how's that going in general? How about the other annual reports for all the guardians statewide? Are y'all finding them to be accurate and complete if they're filed?
I've kicked back most of them. and ask them to be. I'm not emotionally ready to talk about the stress of that.
Okay, so in that regard, Miss Lott's annual Guardian report wasn't that much different than anyone else's, except
No,
perhaps that it actually got filed.
that is true. She was, we don't have so much of the issue that she had where it was inaccurate. She didn't include wards. It's mainly been more of not including the applications or not including finances, financials or total estate, that the forms themselves are incomplete rather than missing information regarding the wards.
Okay. And actually that's leads me to, I had a question about Clausen. It's been a while and my memory's definitely subject to not being complete. But I thought one of the issues with Clausen was that there are a lot more, he had more guardianships of the estate that he handled than Miss Lott did.
Yes, individually appointed, he did handle a lot of estates, but he also, I think he still had more person or guardian of the person than estates, but the cases that he did have estates were rather large.
Right. Okay. And Miss Lott, how many estates did she have?
Amy, could you help me out with that?
I will check.
Actually, let me.
But now I have to recount. Hold on.
Yeah, interestingly enough, I was looking on one of the reports, but it said she reported, I don't know how accurate this is, that she was managing $1.5 million worth of assets.
And
I did
then
not gather that was that size of assets that she was under, but that's what she reported.
on the second report that she sent us, it was 2.5 million.
Oh, okay.
And is it, did I dream this, or did you later find out she was also doing some decedents estates?
Yes, she is appointed to decedent estates.
So according to her report, there's approximately 20 estate cases.
Okay. And those are all active or over time?
I counted the ones that were active for 2023.
She did have a quite a few wards that did pass away in 2023.
Okay.
But if I read correctly, there was one ward that had been dead almost a whole year, and she hadn't filed the final report. Wasn't that?
Right.
Yes.
Now, I do have a question. Also in the commission's meeting, and this goes back to what you were discussing earlier, Mr. Renard, that we had hoped we were being careful when crafting the conditions of the suspended certification, but it looked like it was going to take too much time, excessive staff time, because I know that the staff is overloaded as is. What did we miss? What was going to have to be audited with regard to the Guardian's quarterly reports on each of the wards involved in the complaint?
You're on mute.
I think what happened was following the January submission of her annual report, we realized that when she turns these in, we would have to go back and double check. Are they accurate? Did she include everything? Check with all the counties. And I think that was just going to be something that was going to be, it wouldn't be just, we can just take the report and accept it and you're done. It would have to be something we'd have to go and look. And I think that would be a lot of time to audit all of her cases every quarter for 5 years. And I apologize, that was my suggestion because of the length of the probated suspension, but
yeah, okay, I hear that. It was my belief that the way we had crafted it was that if anything was missing from it, that the reports would require file marked copies of all the court documents required. And therefore, if something simply wasn't there, then that report was inadequate and that, failed to comply right there without having to go back and check. But I was wrong about that?
I think no matter what they submit, we have to double check. We can't just accept it. We have to look at the cases and make sure that they did file everything. So, I'm not sure if you're right or wrong. I just know that it's going to take a lot for 5 years for us to monitor her caseload every quarter.
And that's
Okay.
kind of what
And we
I was-
we don't normally recommend that, and I shouldn't have recommended that because we don't normally do that. We've done that in the past years ago. It always becomes a burden on our staff to stop and go back and double check everything they're doing. It's almost like you're reinvestigating the whole case every time.
Okay, then. Well, that's something we'll keep in mind moving forward.
And that was my suggestion. Again, I apologize to the committee for bringing it up.
Now, I believe that one of the commissioners had questions about the Ms. Lott practicing law without a license. Did the committee, did the staff look into this at all?
I know that Amy looked at a past filing and noted that it was not prepared or signed off by an attorney.
Okay. And does the staff have an opinion as to whether or not that amounts to the JBCC reporting Ms. Lott to the state bar or other proper authorities for practicing law without a license?
I guess I had some concerns, Mr. Chairman, because I couldn't find what statute or minimum standard she violated by doing that. I looked up the unlicensed practice of law definition, and it wasn't very clear if this would constitute that. So in light of the fact that I don't know what she violated, it would be a little difficult to submit a complaint without that information.
I see. And did the commissioner follow up with the staff and indicate whether or not the commissioner in his capacity as a officer of the court had made such a report himself?
I didn't ask that, and as far as I know, this commissioner didn't take any action. I think he wanted staff to take that initiative.
Okay.
But I wanted to bring
into, oh, go ahead.
I wanted to bring it before the committee.
Okay.
I can find a violation, but I don't know if you all know if there is something that I've overlooked that would warrant it being reported.
Well, in the as far as an attorney being required to represent a guardian in court, that is the law. It's not stated explicitly, however, in the estates code. In fact, the only mention I can find of it is that specifically a guardian of the person is allowed themselves to file an annual report of the person, but only that. So presumably everything else must be filed by an attorney on behalf of the guardian. Judge?
There's case law to that effect. And there's actually, I don't remember if this one was reported or not, but it involved me because I had ruled in a case that this was an attorney who was filing in a decedent's estate, that she needed an attorney, and the Court of Appeals said only if you are a personal representative or wanting to be a personal representative do you have to be represented by counsel. But
that's my understanding. Yes,
that there are that I'm aware of at least 3 cases, one that are Court of Appeals cases that say that a personal representative, which a guardian is a personal representative, has to be represented by counsel. And there's a one exception for the guardian of the person to file an annual report, and that's statutory. And if I thought in standards or rules somewhere it said that the guardian had to follow all state laws regarding guardianship.
Yes. Yeah, and I believe that's minimum standard 5D.
So that would be the one that would be available for that. But I'm not sure that I think a good part of that is the judges letting that go, I guess is what I want to say. Because ultimately it's the judge who has to say, guardian, you can't do that. I mean, we can say it because they're not following the law, but I'm not sure about whether we would be the ones that should be appointing them to the unauthorized practice of law.
Yeah.
I don't know.
Yeah.
It's something that I brought up in the meeting that we had previously, because we were shown documents from Montgomery County where she had filed the motions without an attorney, and they weren't annual reports. They were other types of, well, they were the motions to place the wards in her home, you know, the home that she owned with her daughter. And those she signed individually. She didn't have an attorney representing them.
Yeah, I saw those as well, and yeah, she was required to technically. Now, I will say, once a guardianship of the person only is created, it can become burdensome on a guardian of the person if there's no estate and no means to pay an attorney, to have an attorney represent them on everything other than an annual report. You know, there are other filings or reports to the court that a guardian is required to make, you know, a change of residence or moving into a more restricted facility, whatever. And technically, a guardian of the person should be represented by an attorney and making those reports to the court. As a practical matter, however, you know, courts are going to have to wrestle with that as they go forward. And definitely with regards to guardianships of the estate, there definitely must be an attorney overseeing the preparation of accountings and filing the accountings on behalf of the guardian, as well as applications to sell property and whatever else happens. I don't believe, however, that although an attorney is required and is a violation, and not having one is a violation of minimum standard 5D, that it amounts to practicing law without a license. But I'm not an expert in that area. Another matter that was brought up by some of the commissioners was that by just their view of the case, they believed that there were kickbacks happening and that the guardian was receiving kickbacks. Did the staff find any evidence of that?
Not that I'm aware of. We didn't see anything. Whether discrepancies in the accounting or some of the reimbursements, yes, but we aren't able to assume, or we don't have any evidence that says that there was a kickback to anybody.
Okay. And in addition to that, there was also an allegation or a remark from one of the commissioners that the reason that no one had complained about the guardian to the courts was that she had an in with the courts. How many, there were multiple courts involved in this with these complaints, were there not?
Yes, and the bulk of them were with Harris County, where she previously worked. The next one where she had the most would be Montgomery County.
Mhm.
but definitely Harris County was her previous employer.
Okay, so there were several courts though involved.
Yes.
Montgomery, Harris.
Waller.
Did she have any
Fort
cases in
Bend.
Waller? Yeah.
Yes, she had cases in Waller.
And she had some in Fort Bend also.
Yes.
Oh, I'm sorry, Judge. You cut out a little bit on my audio.
She had some in Fort Bend County also.
Fort Bend. Okay. So either she has an in with all the courts, or anyway, I'll leave that one alone. Okay. Now, has she submitted her resignation or submitted an offer of resignation?
To
I
the
believe
court
she
or
submitted. Go ahead, Melinda.
Oh, I didn't. I was just trying to get clarification. Resignation to us or to the courts?
To y'all, to the commission, as surrendering her certification.
No, not surrendering. She just said that she was going to resign and would not be renewing her her certification, but she has never said that she would surrender the license.
Okay, and so there's no effective date of the resignation?
I know that she submitted resignations to the court, but I don't know when she intends to completely
Oh.
stop and retire, as she said that she was going to.
Okay, and to be clear, I'm talking about submitting the resignation of her guardianship certification.
No, she did not
Just
give
so
a
that we're
date.
okay. So essentially, she's offered that she will submit that resignation.
Yeah.
Is that right?
All she said that she was going to retire and resign from her guardianships. She never said that she was going to. There's no definitive answer from her that she wouldn't ever get back into guardianship, because she would still maintain a license until 2025. She did mention that she was not going to renew it, but there's no definitive answer that she definitely would not.
Okay.
What I got from Mr. Tamborella's letter is that she just wouldn't take any new cases, and when her license expired, she wouldn't try to renew it.
I agree.
Yeah, I'm looking at Mr. Tamburello's letter now. Let's see.
Very frankly, his letter left me very upset.
Okay, yeah. So he mentions her decision to resign her cases, but I don't see a mention about her certification itself. Does that match everyone else's observations?
Not just mine.
Yes, mine too.
Okay. All right. Are there any more questions or issues or things that anyone would like to bring up?
I would like to confirm that Vina procedurally at this point, just for clarification from me, if the group today agrees with this modified proposal, such as either the total revocation or total surrender and the $5,000 penalty, that is something that will be taken back to the board. Is that how that will work procedurally, or what would be our next steps?
That's correct. A notice of violation letter would again be issued to Ms. Lott, and she would be given an opportunity to either agree to the terms that you all vote on, or she can contest a hearing, or she can contest the sanction or the violation. So she has different routes she can take, but it would be presented to her as another settlement offer.
You feel that this modification is warranted based on everything you and Melinda and so forth have found in this regard, and in a reevaluation of the case?
We think so. We did meet to discuss what the appropriate sanction would be initially after the commission's meeting and after receiving information that she planned on resigning and not renewing.
All right, thank you very much.
Mm-hmm.
Well, I'm in favor of moving forward with Vina's proposal, unless someone has something different.
And just for
And-
clarification, Mr. Armstrong, we did say today that we would be fine with the $5,000 penalty. What was
Right.
stated in the investigative report was 10,000, but we're
Okay.
fine with 5,000.
Right. That's what I was thinking, the
Yes.
modification had been, one of the significant modifications. Okay, thank you.
In light of the fact that, even though Mr. Tamburino's letter did not specifically address surrendering her certification or resigning from that, my understanding was that was kind of the gist of his letter. And so in light of that, I believe it would be appropriate to go ahead and accept her offer to resign. And I guess the only form we can do that in is to go ahead and revoke. Is that correct?
You can do it in the alternative. You can ask that she, that either the license be revoked, or in the alternative, she permanently surrender her certification. And then
Okay.
assess the penalty.
And what date would that be the date of the next commission meeting?
Yes, if it's approved at the next commission meeting in May, that would be the effective date. And hopefully she can resign from all her cases in the interim.
Yeah. And she should be able to resign from all of them immediately. Just because the guardian resigns doesn't mean that the duties are over. The duties are over when the court accepts the resignation and, if necessary, appoints another guardian. But until that time, the guardian's still required to continue serving.
And
So hopefully,
out and gets released and all of that.
I'm sorry, Judge.
I said she'll also have to, when the court accepts the resignation, she still has to file the final account of it to the state. And after that's approved by the court, the application to be released, her bond to be released. So there's a period of time, even though she has resigned, where she's going to have to be working on that case. My question is, if we revoke her license prior to the time that she's released by the court, what effect would that have?
What we can do is make it pending, revocation pending the resolution of all her cases.
And require that she then file with the commission or with the board a copy of the order releasing her and her bond?
Yes.
I would caution to say that the courts, as I'm sure you know, sometimes take a very long time. And so it's not they'll take months and months at times to appoint a successor. And so I guess during that time, she would still be able to work as a guardian. I don't know how long generally those counties will take, but I do know there are some counties that take a long time, months and months at times.
Yeah, months and months. Yes,
Not throwing any
definitely.
county under the bus, but just going to throw that out there.
And forgive my fading memory, but Judge, is it 30 or 60, 90 days to file an annual accounting each year after the qualification date?
You mean in a guardianship?
Yes.
They have a 60-day grace period, I think.
60?
Right.
Great. Okay. All right. So, so she can immediately file resignations in all her cases and get the ball rolling on closing them out. And then it would be up to the courts to, because once she files a resignation, then that'll trigger the time period for final accounts and everything to start being filed on the estates.
What will trigger the filing of the final account is when a successor guardian is appointed.
Right. Well, correct, but that's, waiting for the courts to do their thing too as well.
I know, that's
Yeah,
why
I'm thinking,
I'm concerned.
yeah, I'm thinking about some kind of language, perhaps that, you know, she, another agreed order in which she agrees to immediately submit resignations and final accounts where necessary in all her cases, and then surrender her certification upon the court's approval of the last of the accountants. What do you think about that, Judge? Does something like that?
Yeah, I think that probably what's gonna be the biggest problem for the courts is finding a successor guardian.
Agreed. Yeah, they're
And
going to have a big hole down there.
especially Montgomery County will have.
Mhm. So how does that work for the commission and the staff? A conditional, or not conditional, but trying to time it so that her license is effectively, her certification is effectively surrendered when all the cases are finally closed and done. Because it occurs to me that if it's revoked or she loses her certification, she's still on the hook for the cases. And if there's any problems with the other cases that would have otherwise required intervention or additional complaints to be investigated or whatever, doesn't the commission lose its jurisdiction, if you will, if she's no longer a certified guardian?
That's correct.
So what kind of language can we use to make that effective? That she maybe give her a month after the next commission meeting, if this is to be accepted. The commission's going to do what it believes is appropriate, I'm sure. But say a month after the next commission meeting, all resignations in all cases must be filed, and then and final accountings as well, and get that going. There may, as Judge Burwell has said, we might be looking at a year, by the time all the courts get everything reviewed and approved and closed out. But I'd rather still have her under the jurisdiction of the commission if there are any issues moving forward with her getting out of these cases. So does some kind of language to that effect work, that she has a month to submit resignations and then shall surrender her certification when all the cases are closed?
I think we can make the effective date. We can say the effective date shall be upon the courts accepting the final accounting or something to that effect.
And closing the estate.
And closing the estates.
Because an accounting can be a final accounting can be approved, but there's still extra steps that the court has to take, and then there actually should be a closing order, releasing the bond, etc., on everything. So I think that's what we're looking for a case to be finally closed. Is that right, Judge?
It would actually be an order releasing her and her bonding company.
Yeah.
Not be closing the estate, because the estate would still stay open. So what it would be.
Right. Thank you. Mm-hmm. So then that's going to be until receipt or until the court issues an order releasing her from her duties of guardian and releasing her from her bond.
But for our purposes, do we need that? I mean, that's going to be regulated by the court. That's her bond. That's her liability. if our goal is just to get her out and the court says, signs an order and appoints a successor, can we not leave the accountings and all that other jazz to the court to figure out if she's completed that? Because we can't call her before us, but that judge could call a show cause if he or she is mad that I'm not getting the final report. So wouldn't we just want no more, you accept no more cases, you resign, and then notify us once you have a successor, and we can leave all the court proceedings, the final accountings, the final reports to the court to deal with her, because they really have that jurisdiction, in my opinion, more so that we monitor it. We may ask her to provide those paperwork to us, but I don't know that we need to be held up waiting on the court procedures doing that, as long as she is no longer practicing and using the licensure that has been given to her, I would think.
Well,
That makes sense.
Now, I think it's more
So what is-
complete, Jamie, what you're saying. I like what you're saying in regard to getting. I think it'd be great to have our file, but just so we're not staying on the hook for so long. And because Mr. Trambrello, I mean, that's to me kind of one of the interesting things. We always work that imperfect balance between what the court controls, what we control, kind of hokey pokey, how far can we go in, how far can we come out type of deal. So I think that would kind of be my viewpoint, is how little we can do to get the maximum benefit out of completing the licensure, getting what we need to complete our task in this regard, and just let the courts figure out the rest.
Okay. Judge, in a realistically, properly, well-functioning probate court, what do you think the turnaround time should be on an annual accounting or a final accounting?
it depends on when a successor is appointed, because you can't do the final accounting until the successor is appointed.
Right. But let's just pretend that they do have a successor available.
It shouldn't take long to do the accounting as far as that goes. It has to be, a final accounting has to be posted, so that's a 10-day posting period. So depending on, that may be 1 week or 2 weeks, depending on what day of the week it's filed, before the court takes it up. Before the court can take it up. Now, a final report, if it's a guardianship of the person, that's a different story. But
that should be pretty quick if there's a successor guardian. Yeah. Okay.
You don't have to post a final report, but you do have to post the final account.
Right. And assuming that there may need to be court inquiries and guardian follow-ups on at least one of the two cases, I wonder if we should just give a little bit of time padding, not too much. I like what Mr. Armstrong was saying, let's get this over and done with and be as effective as possible. But what if she submits her resignations within a month, 30 days of the commission's acceptance of the order, and then surrenders her certification 90 days after that, or 60 days. Mr. Armstrong, what are your thoughts about that?
Yeah, I think that's great. I mean, my thought is she doesn't need the license she holds to complete the annual accountings, the annual reports. She's the guardian. She's still on the hook. She's got to close that aspect of the guardianship out. So yeah, I think that would be complete for our purposes. Something along those time periods.
Do you think 60 or 90, or Judge Burwell opinion, how many days?
I would think 60 days should be enough.
Okay.
Because I would assume she's already, from reading his letter, I I got the impression that she had already filed, letters of resignation in all her cases. Now, I mean,
I thought
I
there were
say-
some of them, but not, I didn't think all yet.
Yeah, I like the part in Gus's letter where he says that there are more to be filed. So I think kind of what Melinda ran into. I don't think they know the full extent of what's in the bucket as far as what has to be filed. They may have been 5 or 10 filed, and there may be tons more left to be done. So I'm not sure he fully understood how much there is.
Okay, so we're then looking at okay, so 30 days after the commission.
60 days after, 30 days after May the 3rd, plus another 60 days, we are in June, July. We're in almost in September. By September, she should have filed all of her final reports or final accountings. Maybe we can break it down differently for final reports or final accountings, because there's a big difference in what has to be done there.
Well,
But I just
true.
1 day period. So if we make it that she has to file a letter of resignation in every case by May the 3rd, by 30 days after May the 3rd, and then within 60 days after May the 3rd, have filed final accountings or final reports, we are in the middle of summer. And if she's actually, I mean, she should be, her accounting should be easy to do because she should be working on them now. Actually, she should be working on them on all of them every month, but that's beside the point. What should and is.
So 30
It,
days to resign, 60 days for the filing of all final accounts and final reports of the person, and then 90 days to effective surrender of the certification.
I would say that's plenty time.
Based on her timeliness to this point, what do we do if she doesn't do those things?
That
Well,
would
as you
be
said,
another-
that's up to the courts.
And that could be another enforcement action against her for non-compliance of a final order.
Yeah, that was my thinking about, making sure that the commission still had jurisdiction over her certification up to
Okay.
a certain point. But like you
Yeah.
said, I think, there's a balancing point somewhere we got to meet.
But can we, to me, there's got to be an economic incentive because Gus's letter primarily emphasizes only the fine. He talks about all the other jazz, but it's only the fine that he ends up with. Can we leverage that position and say, this is your penalty, but if you don't timely file this, your penalty is going to be $10,000. I don't know. I'm just, Vina, and I need your help in this regard. What can we do? Because there has to be something hanging over your head to cause you to act in this instance. Otherwise, we're just going to get a bunch of late reports that are going to be incomplete. And once again, we have no teeth to do anything with, in my regard.
Well, I think that
the reason why you can't do
violate,
that.
I think within that 90-day period after May the 3rd, anything she doesn't get done would itself be another violation. If she resigns and then doesn't file a annual report or final report, that would theoretically be another violation that would be subject to a penalty, a fine.
Yeah.
And that would top it off. But I like your idea of trying to, use a carrot, if you will. Judge Burwell?
The only thing, It's if we have a court who doesn't do their part, that would prevent her from doing her part.
Well, she has it under her own power, under her own control, if you will, to file the resignations and then file the final reports and final accountings. Now, there may be a situation in which an extraordinarily long period happens and she has to file a supplemental final account, but that'll be between her and the court, I would think. But within her control is at least getting the initial thing started, resignations and the filing of the final reports and final accounts. And then after that, it really is going to be up to the courts.
The resignation letter is totally under her control. The filing of the final account is contingent upon the court appointing a successor.
That is correct. That's why, we were trying to find a balance in time, because either we, if we leave it open-ended, then the commission's on the hook, so to speak, for monitoring her perpetually.
I understand, but what I'm saying also, that there may be some circumstances when, because of the courts doing their job, she couldn't have done her part. And that's the only thing I have, we need. I would assume, are we going to be sending something after May the 3rd, sending something to the courts?
We do send them the final order.
Okay. So they be aware that, court, you're on the hook for getting this done.
Yes, ma'am.
I think I'm going to be looking into filing a patent for a perpetual motion machine. So in that regard, do the 30, 60, and 90 days, are they somewhat effective? I mean, I don't think we could just leave it totally open.
I think so.
Okay. So then it would be along the lines of, okay, so the agreed order would be that the guardian agrees to have filed resignations and all existing guardianship cases 30 days from May 3rd, and then 60 days from May 3rd, all final accountings and final reports must be filed. And then 90 days from May 3rd, her certification is either surrendered or revoked.
Can we just add permanently surrendered and permanently revoked?
Yes.
I think so. Yeah, that's fine. Does that work for everyone? Or is that the best achievable outcome for today that everyone expects?
Oh yeah, I think it'd be fine.
The 5,000 within 3 years.
Mhm. I would be in favor of moving the accounting requirement out of there and bumping that up to a year. But personally, to be honest with you, I'm not really worried about the accountings. That's the court's issue. I mean, and if she doesn't turn it in, I mean, what's her loss in that? So, I mean, I would be fine with moving the 5,000 fine up, not wait 3 years. I mean, she's let it roll this long.
I would say we make that a year.
I agree.
I agree also. Where did the 3 years come up? Is that standard, or how did we come up with that last time?
It's not standard language. We just came up with it because it's a little more than what we typically assess against respondents. Just gave her additional time. It was pretty arbitrary.
Is there a standard or more routine time limit given to pay a fine?
It really depends on the profession. For process servers, we usually give them a year. If it's a fine of about $1,000.
If she's going to be filing final accounting, she's also going to be, in a lot of these cases, getting her
Hey.
her 5 in and
Yeah.
out, and so she should be able to do it within a year.
I will mention that she was quick to say that she would pay the administrative penalty right away when it was,
I
I
think
think, about $5,000.
I was thinking the same thing, Vina.
Oh, she said it would be paid right away?
Yeah, at the last committee meeting, she did say she would be quick about submitting it.
Right.
So
Well, do we want to give her 90 days for that?
no, I think
And that way, hopefully everything's wrapped up in 90?
I'd say put it 90 days. Why not? I mean, she's already said she was willing to, and we can say based on your statement during your hearing, you were willing to pay it. So wrap it all up in 90 days.
I'm sorry, Judge, what were you going to say?
I was going to say that would make a clean cutoff of everything. If the date for the penalty and for the surrender is the same, that would be a clean cut.
Okay. All right. Does this work for the staff?
Yes, sir.
Has anybody, did anybody have anything else to address, or has anybody put the wording together for a competent rendering of a motion?
Mr. Chairman, I think you stated it well, and you can just make the necessary amendments regarding the payment period and
Okay, all right, here we go. I move that a recommendation be made that 30 days of the commission's acceptance of an agreed order or approval of an agreed order in this matter, the respondent will file resignations in all guardianship cases in all counties for which she is guardian. 60 days from that day, all final accounts and final reports of the person must be filed. And then 90 days, then either the 90 days after that, the guardian either submits her permanent surrender of her certification, or the certification is permanently revoked. Additionally, a $5,000 fine will be assessed with 90 days to pay.
From May 3rd.
90 days from, the date the commission accepts it would presumably, if they do, would be May 3rd.
I second the motion.
one thing, Mr. Chairman, I think you said agreed order. There's a chance that she may not agree to the settlement order, so we can state that as simply a sanction.
Okay,
Because if she contests it, that would be the proposed sanction.
I second the motion.
all in favor?
Aye.
Aye. Okay, the motion carries. Moving on, are there, who wants to attend the May 3rd meeting?
You do such a good job at it, Jamie.
Yeah, I
We
wouldn't
can
mind
never
a break from
replace
purgatory.
you.
Well, I will be there then. I will plan on it. And are there any, I don't see anybody else on, were there any members of the public on? No.
I would like to receive the Zoom notice of the meeting and to just listen in,
We'll add you to the list, Judge.
because I did watch the YouTube of the other meeting, and some of the comments by some of the people who aren't really familiar on how the courts work. Were
Commissioners who shall not be named. Sorry.
No, I mean, let's face it, the courts have a hard time finding certified guardians.
Mhm.
And if there is somebody available, that's who they look to.
Mhm.
There aren't that many around anymore. And I mean, I don't have to find them anymore, but I did at one time, and I know what problem it is.
Mhm.
And what's scary to me is if it is true that these are cases that she has that the guardianship program won't take,
Mhm.
then
Yeah, I've got cases now with clients in psychiatric hospitals waiting for guardians that have been waiting for over a year, and because there's nobody available, the
Mhm.
only alternative is to keep doing extended 1-year commitments over and over.
Yeah.
And I'm sure it's more expensive to hold them in one of the hospitals than it is perhaps a nursing facility or some other appropriate place that might be able to help them. So it's expensive too.
And Jamie, just to let the committee know, there's 459 active guardians, and I think like 80 of those are provisional.
Wow.
That's for the whole state.
So
does that include all the ones that are on programs like Friends for Life?
All of them, all certified guardians.
That's not nearly enough.
Mm-mm.
that's less than 10 per county. Wow. And on that happy note, unless anybody has anything else, we'll adjourn. It's
We have a future meeting on April the 23rd.
Yes, ma'am.
Okay.
what day of the week is that? Does anybody know off the top of their head?
It's a Tuesday. Tuesday.
Tuesday? Okay. All right.
Right.
Well, thank you, everyone. It's 10 minutes after 11, and this meeting of the Guardianship Certification Advisory Board Complaint Committee is adjourned.
Thank you. Y'all have a good weekend.
Thanks, guys. Have a great one. Take care.
Thank you, guys. Bye.
Thank y'all.
Bye.
Melinda?
Uh-oh. Did you have a message for her?
Yes, I did.
Okay.
I'm sorry I haven't been able to do any more calling to the different counties to do their reports.
Okay.
But I'm getting better. And so next week, by that time, I should not be running fever and all of that crap anymore. And I should be able to get back to working on that.
Perfect. I will let her know. And yes, you get to feeling better. All right. Bye.
Bye.